special installment of our series, From the Front Line, our virtual series, which draws upon the experience and insight of our faculty, our alums, and other friends to discuss and dissect many of the issues that our nation is grappling with at the current moment. And today's event is entitled Ruth Bader Ginsburg, Celebrating the Life of a Legal Giant. And we intend to do just that. While Justice Ginsburg's legacy far exceeds the time that we have together tonight, I look forward to the chance to spend the next hour discussing and reflecting on some of the many ways that Justice Ginsburg made her mark on the legal profession and on our nation, as well as talking a little bit about what may happen next with the vacancy that her death has left on the Supreme Court. Before we get to any of that, I'm going to do a very brief introduction of our distinguished panel. This isn't nearly the lengthy introductions that they deserve, but I know that you want to hear from them, and so I'm going to keep these introductions short, but I'm just delighted to have them with us, everybody with us this evening. First, we're joined by UCLA law professor John Michaels. Professor Michaels is a graduate of Williams College, Oxford University, and Yale Law School. He clerked for first Judge Guido Calabresi of the U.S. Court of Appeals for the Second Circuit, and then for Justice David Souter of the U.S. Supreme Court. Professor Michaels joined UCLA in 2008, and he focuses on constitutional law, administrative law, national security law, the separation of powers, presidential power, regulation, bureaucracy, and privatization. And he also frequently comments for the press, as well as on blogs, as well as being a very productive and prolific scholar. Next, I'm delighted to welcome Jocelyn Samuels, who's the executive director of the Williams Institute here at UCLA Law School. Before joining the Williams Institute, our institute that focuses on sexual orientation and gender identity, law and policy, Jocelyn had a distinguished career in civil rights law, including serving as director of the Office for Civil Rights at the U.S. Department of Health and Human Services during the Obama administration. And I have some bittersweet news to share about Jocelyn. Just yesterday, she was confirmed to a Democratic seat as a commissioner on the Equal Employment Opportunity Commission, the EEOC. We are certainly going to miss her here at the law school, but we are thrilled that she's taking on this important role. And we know that she'll continue to be an ambassador for and an enthusiast about all of the tremendously important work that takes place at the Williams Institute and at UCLA Law School as a whole. So congratulations again to Jocelyn Samuels, and you're going to be part of our UCLA family even in this new role. I'm thrilled to welcome this evening two distinguished judges on the Ninth Circuit Court of Appeals, both of whom are also UCLA Law alums. First, I want to introduce Judge Mclean Wardlaw, who's a graduate of both UCLA and UCLA School of Law. She clerked early in her career for Judge William Gray of the U.S. District Court for the Central District of California, and then joined O'Melveny & Myers, where she became a partner. In 1995, she joined the Ninth Circuit Court of Appeals, where she was the first Latina woman to be appointed to a federal appeals court. She's been extremely distinguished as a judge, and I'm also very lucky to count Judge Wardlaw as a member of my board of advisors. Last but certainly not least, I'm thrilled to have Judge Paul Watford with us. Judge Watford received his undergraduate degree from Berkeley and then his JD from UCLA Law School. After law school, he clerked first for Judge Kaczynski of the U.S. Court of Appeals and then went on to clerk for Justice Ruth Bader Ginsburg. After his clerkships and a brief time in the private sector, Judge Watford became an assistant U.S. attorney in the Central District of California. He returned to the private sector and became a partner at Munger, Tolles & Olson. And then in 2012, he joined the Ninth Circuit Court of Appeals, where he very quickly became extremely well regarded as a jurist as well. So that's a brief introduction. Again, there's so much more I could say, but please join me in welcoming our distinguished panelists. And let's go ahead and get started. I'd like to begin with a question for every member of the panel. First of all, the outpouring of grief we've seen from people of all ages and all walks of life in response to Justice Ginsburg's passing has really been quite remarkable. Many Supreme Court jurists, though of course prominent and well-known, don't have this kind of rock star quality in pop culture as well. And that's kind of distinctive and interesting. And at any point, I'd welcome hearing any of your thoughts on what produced that or what created it. But it makes it especially difficult to take stock of her many accomplishments and contributions. But I'd like to ask each of you to say something briefly about what you think will go down as one of the most important parts of her legacy on the court or on her time before the court. That when we look back from a greater distance, what do you think we're going to especially remember about Justice Ginsburg? Let's see, Judge Watford, why don't I begin with you for this one?
Sure. Well, I mean, I think it's certainly that she did more perhaps than any single person that I can think of to advance the goal of achieving full equality for women in society. You know, I think what's remarkable about her legacy, both as an advocate and as a jurist, is that when she started out, especially in the early 1970s as an advocate, I mean, the task before her must have seemed so daunting, because we're talking about not just attacking a legal structure that had made women second-class citizens for the most part, but just an entire societal construct that must have just seemed, you know, like, how would you even begin to dismantle that? But I think what she recognized was that until the legal constraints that had been placed on women and that had rendered women unequal in society, until that was dismantled, you couldn't possibly cause society's views of women's place and women's role to change. And I think if you just trace the arc of her work from the early 1970s until now, that's, in my mind, the principal legacy she's left. She just completely changed the world that we live in for women.
That's right, and she lived it too, right? When she graduated from law school, first in the class, no law firm would hire her nonetheless, right? So it's kind of amazing.
That's exactly right. Yeah, no, I mean, that's a perfect illustration of how things have changed. I mean, she should have been a Supreme Court law clerk and then had every single opportunity in the legal profession open to her. And instead, yeah, she literally could not get a job and was barely able to get a clerkship herself if it weren't for the efforts of her main mentor at Columbia to really put pressure on a federal district judge to be willing to take a chance on hiring a woman, believe it or not.
Right. Wow. Judge Wardlaw, what would you like to add?
So I think she had so many aspects of legacy that she leaves for us, particularly the last decade, where she became this iconic voice of power for women and influenced so many women and young girls. But I'd like to expand on what my friend Judge Watford said. I was thinking about her legacy and everything she did for women. But what I really think about it is that it wasn't just for women. It was really advancing the concept of equal citizenship. And I think about it that way because I go back to when I first heard of Ruth Bader Ginsburg. She was a professor at Columbia Law School, and my constitutional professor, law professor at UCLA Law was Ken Karst. And he mentioned to me, I should read this work she's doing on gender discrimination, all of that. But I also knew, because she also spoke at his memorial recently, I also knew from her side that she had called upon Ken Karst. He was doing all this advanced writing on the issue and the concept of equal citizenship and belonging in America. And she was calling on that aspect of his thinking in her work that did advance the rights of women in an immensely important way. But also, as she went on and as she became a judge, and especially a Supreme Court justice, followed through. It was a theme of her, and it wasn't just about the rights of women. It was about human rights and the rights of citizens to all the rights and privileges of the Constitution and the 14th Amendment. and Title VII. And I just started thinking about it this way just recently, because I mean, I think obviously we know what she accomplished for women, but I think she continued to do that for other people on a, day by day, decision by decision, forging ahead with each problem, like Paul, throughout the arc of her career.
Thank you. That's great. Professor Michaels.
I apologize. I think there's two key points that I would associate with Justice Ginsburg in her career. And I think they're both singularities, or if they're not singularities, we're unlikely to see the likes of a Ruth Ginsburg again. I hope, but I have my doubts, we'll see someone who is such a seasoned and successful fighter, a champion for equal rights on whatever the playing field happens to be. But the way in which the judicial politics have become, I fear that we won't have someone like that. Justice Ginsburg, as was addressed, was a kind of unparalleled champion and legal mastermind of a movement. And for her to be paired in sequence with Justice Marshall, another singular justice in our history, I think it makes sense to think of them those ways. And unfortunately, I fear they may be unicorns. The second point I would raise is that, but it's related, is I don't know if we'll see another jurist as seasoned, as accomplished, and as patient as Justice Ginsburg was, in part because of not only all the challenges she confronted, but she was quite senior in her career when she was elevated to the Supreme Court. She spent a pretty good career as an academic, a pretty good career as an ACLU champion, a pretty good career as a DC Circuit jurist. And then on top of that, she rolls into the court and serves 27 more years. And so, Jennifer, you mentioned the kind of notorious RGB. That came a little after my time. I was just in awe of the woman. Every time I saw her, there were two justices. I don't know if I should be saying this, but there were two justices who intimidated me, and they were good friends. And it's not because I don't know opera, but it was Justice Scalia and Justice Ginsburg for very different reasons. Justice Ginsburg carried herself with the dignity and decorum, and when she spoke, everyone listened, and she spoke quietly, and she didn't need to bluster. She didn't need to raise her voice or throw zingers in her opinions. And I think that maturity is something that we are going to sorely miss on the courts as we progress or continue on as a society, as it were.
Thank you. Thank you for those comments. Executive Director Samuels.
Well, thank you so much. And it's such a privilege and a pleasure to be here with all of you and with these distinguished panelists. I'm feeling intimidated by being on the panel, so I can only imagine how I would feel about Justice Scalia and Justice Ginsburg. I think I'd echo what both Judge Watford and Judge Wardlaw have talked about, and amplify Justice Ginsburg's enduring contributions to ensuring equality in society by saying a couple of things. The first is that I think that she really enshrined the understanding that sex stereotyping is a form of sex discrimination that is as damaging and as limiting as any other form of direct discrimination of people saying, I won't hire women or I won't rent to women. And I think she also managed to elevate the understanding that it doesn't matter whether the stereotypes arise from animus or paternalism, they are equally limiting and constraining, even if they are in some measure in the eyes of their adopters, well-intentioned. So I think that those are two really enduring strands of her work on sex discrimination that have had ripple effects outside the context of how women are treated vis-a-vis men. The other thing I'd say is that I do think that she illustrates how critical diversity of experience is for the High Court. We've heard a lot about the fact that all the justices come from Ivy League schools, and up until recently they were Catholics or they were Jews. And I think it is not just in background, but in experience that justices bring a perspective that is critical to ensuring that they read the law in a fair and a just way that understands the impact that laws and abstractions have on real people. And I think Justice Ginsburg did that in a way that, sadly, I agree with Professor Michaels, is unlikely to be repeated again anytime soon.
Thanks. I want to follow up on something that Professor Michaels said. He talked about when he was a clerk for Justice Souter, Justice Ginsburg was a presence for him, even though he wasn't in her chambers. And I want to turn to you, Judge Watford. You clerked for her. I'd love to hear a little bit about that experience and have you share, some sense of what that was like. Anything that you're able to tell us about that experience.
Oh, well, I could easily eat up the rest of the time, unfortunately, with just so many great memories. I mean, as you would imagine, this past almost week now is just so much of that has been flooding back and reconnecting with my former co-clerks and the like. There was so much that was wonderful about her. And I guess I would say I did not find her in chambers to be intimidating, to be honest. She was very soft-spoken, as Professor Michael said, quite reserved, so not a real boisterous, outgoing person. And that very much was her husband, Marty. The two of them were polar opposites in terms of personality, and he was a frequent presence in chambers. But I would just describe her as one of the kindest and smartest bosses anyone could ever hope to have. She was, without question, just the most brilliant legal analyst that I've had the privilege of working with. She just was extraordinarily smart, but at the same time, she was so considerate and so caring. She expressed such caring toward her law clerks. And I guess I'll just give a couple of small examples. For everyone's birthday in chambers, her judicial assistants, her messenger, the law clerks, we would always have a celebration where her husband was alive at the time that I clerked, would bake a gourmet cake of some sort. He was just a fantastic chef and baker. And we would have a little birthday celebration in her office at a big round table. She would bring in tea, and she just wanted to acknowledge that she cared about each one of us, and that was a regular tradition within chambers. She would frequently bring back gifts for each of us whenever she went on a trip, of some distance, and it would be an individually selected gift for each of us that just again showed that she was thinking about us when she was traveling. She had a tradition of inviting the clerks and their significant others over to her home right before the term started, either right before the term began in October or right afterwards. And Marty would cook this amazing gourmet meal, and we would all just sit down together in her home, and she would just entertain us, and get us to bond as a group. So I really enjoyed the experience of working with her. I've tried to absorb as many of the lessons that I could when I watched her in action in chambers, and tried to do as much of that as I can as a judge now myself.
Yeah, that's lovely. Thank you for sharing. None of the rest of us had the privilege of clerking for her, but does anybody else have, I think probably all of us met her in different ways and forms. Does anyone else have a sort of personal anecdote they'd like to share?
Well, I'll share. We did early in my career, and I guess she'd been on the Supreme Court early in my career in the Ninth Circuit, and she'd been on the Supreme Court for a bit. We did the moot court at Pepperdine Law School. And both of us showed up with our husbands in tow. And Pepperdine Law School didn't usually have judges show up with their husbands coming to watch them and support them. And we had a really wonderful time in discussion, but one thing we discussed was that both of them were colon cancer survivors at the time, and they were in remission. And we talked about how long you could live in remission. And it was a really moving day for us.
Thank you for sharing that. I'd love us to turn now a little bit to her opinions and to some legal substance. I think our audience has a lot of lawyers, law students, alums, some prospective law students. A particular welcome to you if you're thinking about law school in the future. And I'd love to ask each of you to perhaps talk about some opinion of Justice Ginsburg's that you find that's one of your favorites. It doesn't have to necessarily be one of her most important ones, though it can, but one of the ones that's your favorites and why. And let's see, Professor Michaels, let's start with you for this one.
Thank you. So in class, I don't stress doctrine particularly heavily. And part of the reason may be, I was thinking about this when going through Justice Ginsburg's cases, is I don't have enough Justice Ginsburg cases in my little corners of the world. She wasn't a big writer in administrative law or national security law. And maybe I'd feel differently about my sense of jurisprudence had I had a more skilled craftsperson helping support me in my endeavors. But so I'm gonna work a little outside of my core area of interest, of expertise, and talk about an important voting rights case, which is Shelby County. And I'm going to choose a dissent because I think, for better or worse, Justice Ginsburg's legacy is in part tied to some of her dissents. The issue in that case, for those who don't remember, is that there's a question about how much to give reliance on kind of historical practices of discrimination as evidence that those jurisdictions need to have a clearance process before they can tinker with their voting rights regime. And the majority cast that aside and says it's time to move on. The country has moved on. We're no longer where we were when the Voting Rights Act was passed, and they moved past it. And Justice Ginsburg strikes back pretty strongly, and for her quite strongly, pointing out that there's a real kind of problem with that. And the line she uses to say that, basically to say that precisely because there's no evidence today means these statutes are working and still doing their job. And she says throwing out what these things are called pre-clearance review when it has worked and is continuing to stop discriminatory changes is like throwing out an umbrella in a rainstorm because you think you're dry. Okay, and it's important. I think it speaks to a broader set of interests that the justice was keenly aware of, that some of her colleagues or brethren weren't aware of, which had to do with a sense of privilege and a sense of failure to recognize how far certain people have gotten in life, in part because there was a necessary infrastructure to support them. And that's the Voting Rights Act. And it almost reminds me a little bit of the quote that Barack Obama used when he was speaking and basically told a group of businessmen and women that they didn't build that. They didn't build that. Like, remember that you are part of a community that has supported you and created the conditions for you to be the success that you are. And I feel like it's the analogy to a voting district that is not showing signs of kind of racial discrimination or any type of other form of suppression, is to take a step back and recognize how we got to a position of relative calm and don't disrupt that because the job's never done.
Right. Thanks. Thank you for that explanation. And I appreciate you've got a lot to say, even if it's not directly in your wheelhouse. So thank you for that too. Who'd like to go next? I'll cold call if necessary, but I'd love to hear from each of you on this one. So any volunteers?
So I happened to listen to Judge Watford speak yesterday, and I have a kind of a clue about which case he thinks. And I'm going to let him talk about that case because he was there the term when it was decided, even though it's a very important case to me. So I knew I would have to choose something other than that case for this question. So I chose, now I feel like I'm going to be stomping on Jocelyn's toes here. I chose her dissent in Ledbetter versus Goodyear Tire and Rubber, which was also one of my favorite dissents. It was during her period, the period of time from 2006 to 2009, when she was the only woman on the court. And she was very conscious of that. In fact, she'd written about what it must look like to the public to have, 8 big men, and then this one teensy little woman way off in the edge of the court. And in that opinion, the majority construed Title VII very narrowly, or in Justice Ginsburg's words, parsimoniously, to say that for claims of discrimination, and in this case it was compensation discrimination in gender, the statute of limitations for filing your EEOC complaint was began at the beginning of each paragraph, pay period, so that if the woman only discovered years later that for years the men had been receiving larger pay increases every year, even though she was receiving some, she didn't know that they were getting that much more because they were men and they were bringing home the paycheck to support the family. That they would, once at the point in time when the woman discovered that this has been going on, it was too late because the statute of limitations had run. And she took to the bench to announce that dissent. And she wrote just one of her perfectly worded dissents, going through all the reasons why the majority's opinion could be right with respect to other forms of gender discrimination, that is hiring or firing or retaliation or some concrete act. But this was a different form of discrimination. This was compensation discrimination. And for that type of discrimination, it was a very narrow reading of the act to not hold that the woman should be able to sue for the back pay at the point she discovered it. And so she turned to Congress at the end of it and she said, the ball is now in Congress's court. Congress should act to fix the majority's mistake. And what I love about it is Congress acted, and they enacted the Lilly Ledbetter Fair Pay Act of 2009, which just happened to be the first bill that President Barack Obama signed into law when he took office. So that's one of my favorites.
Well, I'll jump in if I might, because Judge Wardlaw, you're right. Lilly Ledbetter was the case I was going to discuss as well.
Sorry.
Have absolutely nailed what makes the opinion so important. I will say I can add a little bit of personal perspective on it because I worked very closely with Lilly Ledbetter after the Supreme Court decision towards passage of the Lilly Ledbetter Fair Pay Act. And for those who don't know, she is an Alabama grandmother who is now in her 80s. She was a manager on the floor of a Goodyear tire plant. So she was in a non-traditional work environment and was the only female manager on the floor. She worked there for 20 years, and for about 18 of those 20 years, she had no idea that she was being paid less than her male coworkers. until someone put an anonymous note in her locker to say, you should know that your colleagues are making significant amounts more. And she is such an extraordinarily tenacious and resilient and determined person that she filed a lawsuit. She won a jury verdict of several $1,000,000 because the jury found that, yes, indeed, she had been subject to pay discrimination. And she had it all taken away by the Supreme Court because, as Judge Wardlaw said, they said, even if you didn't know that you were being paid less, and even if you couldn't have found out because your employer was keeping wages secret, you nonetheless have lost your chance to challenge all of the times in which you've been paid discriminatorily, and instead can only start from the time that you discovered it. So that affected her retirement. It affected her employer's contributions to Social Security. It affected her take-home pay on a daily basis. And I think one of the telling things that Justice Ginsburg brought to her really powerful dissent in this case was an understanding of how pay discrimination really works in the workplace. You don't have access as a typical matter to your coworkers' pay. It is something that employers guard very jealously. And you also don't necessarily know whether your pay is going to continue to be discriminatory. So if you know in year one that you're making $5 less than your coworkers, you may think it's not worth it to challenge it and rock the boat. But then as that gap grows and they get raises based on their base pay and they get benefits that are a percentage of their pay, the gap grows and grows and grows. And according to the Supreme Court, there's nothing that you can do about it. And I think the steeliness in Justice Ginsburg's voice when she read her dissent from the bench about how utterly clueless the majority was about how discrimination works in the workplace was really telling about her power to bring a real life perspective. And the other thing I'd say is just, she did exactly what Judge Wardlaw said. At the end of her opinion, she said, the ball is in Congress's court. And she called them out and said, Congress, this is not a constitutional case. This is a statute. You can fix it. And by dint of extraordinary efforts on Lily's part, they did that. And I was actually at the signing ceremony in late January 2009 when President Obama signed it into law. And the euphoria that we were righting the ship and restoring rights to women of which they had been so unfairly deprived was really a heady experience.
Thanks to both of you for sharing, for bringing that case and that dissent and the aftermath to life. Judge Watford, we've teed up the case that you might talk about. Please go ahead.
Sure. Well, it is the Virginia Military Institute case, VMI. The case actually is titled United States versus Virginia. And I guess I think of that as perhaps her most significant majority opinion. I did clerk for her the term that it was decided. I was not the principal clerk who worked on the case, but I was nonetheless lucky enough to be present in chambers while it was being drafted. And it, this was only her third term on the clerk, third term on the court rather. So it was very early in her tenure, but it was just so fitting that she would be the one to draft the majority opinion, invalidating Virginia's efforts to maintain this really pretty special educational institute that afforded all sorts of benefits, not just in the way of the education that was provided there, but also in terms of the alumni contacts and the like, reserved that just for men. And the case on so many levels just exemplifies the kind of work she began in the early 1970s. It was, the argument the school made for why it needed to be kept all male was that the particular, I can't remember what it was called. I think it was like the adversative method, but it was some supposedly really physically and mentally grueling means of instilling the virtues of the school in men and the like, that women supposedly were just not fit for and not capable of. And really the lasting legacy that I mentioned of Justice Ginsburg in terms of trying to ensure greater equality is so reflected in that case. And I think she, in that opinion, just set out a vision of equality that is, I don't know, one of the most eloquent that I've read, certainly in a judicial opinion. And her basic point was simply this: women are not asking you, the school, to change anything about the way you go about educating people. What you are doing, however, is on the basis of a stereotype that cuts against all women. You are assuming that no woman would either want to or be capable of succeeding in this environment. And you are not permitted to do that. You've got to judge every single individual on their own merits. And perhaps most women would not want to subject themselves to the kind of education that VMI offers. Perhaps most women would not be capable of surviving the grueling educational regimen that the school required. But there may well be some, and they need to be afforded that opportunity to rise or fall on their own merits. And I think that vision of equality is something really that every single one of us, when we go out and do anything in the world, we just want to be judged on our own individual merit and not held back by stereotypes or assumptions that other groups have about what we're capable of just because we belong to one group or another. So I just remember how thrilled she was when she came back to Chambers after conference and the assignment had been given to her. And it just seemed like the culmination of decades of work she had put in as an advocate and as a lower court judge. And now here in her third term on the court, she was given this amazing opportunity to write a really important decision. So that's by far and away my favorite decision of hers. The only other thing I'll add is that it was 7-1. I think Justice Thomas was recused because perhaps his son attended a school that was either similar to VMI or his son might have been affected by the ruling. So Justice Scalia was the lone dissenter. And he wrote his typical, really aggressive, hard-hitting dissent. And I remember we were all stunned as clerks when it came in because we figured, since they were such good friends, that he would go easy on her, in some respects. And he did not in the least. And what stuck with me is that she did not take the tone or the aggressiveness of his dissent personally in any way. They were great friends before, they were great friends after, and she recognized that, listen, we just have very strong disagreements about significant issues, but that doesn't in any way affect our own personal relationship. We're both, here trying to do our best to interpret the Constitution. She wasn't ascribing any kind of ill will toward him. And in fact, I think felt that his dissent helped her make the majority opinion better by forcing her to sharpen her thinking and to respond to the critique that he laid out in his dissent.
Yes, I mean, they had sort of a famous friendship, right? Notwithstanding their very substantial substantive differences. I mean, maybe we'll get back to this later, but sort of I wonder if that kind of connection across really very, very major ideological and substantive differences is going to remain as available as it has been. So we can put a pin in that. If any of you want to address it, please feel free. I want to come back to Executive Director Samuels for a question. We've talked some about gender discrimination in particular. You've spent your career as a civil rights lawyer. I'd love for you to tell us something about Justice Ginsburg and her legacy going beyond gender discrimination. her influence on other kinds of discrimination and maybe even beyond discrimination law. But what about race? What about LGBT issues? What about other kinds of identity characteristics? Can you tell us something about her legacy and role there, and also whether there are any blind spots, any places where we want to celebrate and remember her, but we don't want to lionize her. So I'd love to hear your thoughts on it.
Sure. Well, thank you so much for asking. And, to set the stage as Judge Watford did, what she did in the 1970s as a litigator was an extraordinary transformation of the court's understanding of sex discrimination. Before she brought cases to the Supreme Court, it had never struck down a law on the grounds that the law discriminated on the basis of sex. And in case after case after case, she got the court to recognize that enshrining stereotypes about men's and women's roles was a violation of the Equal Protection Clause. And eventually, as Judge Watford noted, she secured a heightened standard of exceedingly persuasive justification for judging gender-based classifications. Now, of course, part of the problem, and you mentioned blind spots, is I'm not sure anybody really understands what that means and how it relates to strict scrutiny. She had argued previously that strict scrutiny should be the standard for gender-based classifications. The court rejected that and settled on something called heightened scrutiny. And then in the VMI case, she raised the bar by calling it an exceedingly persuasive justification that was necessary to defend sex-based classifications. I think there have been reams of paper and court decisions written on the question of what does that mean and how do you apply it in any kind of consistent way. But whatever the standard, her understanding that sex stereotyping was a foundational problem that led to inherent inequities has now been applied to numerous other vulnerable communities, most notably to the LGBT community. And so it is the notion that people cannot be pigeonholed into traditional classifications about roles based on their sex assigned at birth that led the court to recognize that same-sex couples have a constitutional right to marry. And Justice Ginsburg herself drew that parallel and recognized that her prior work in shattering sex stereotypes was a foundational step in leading the court to recognize that marriage could no longer be defined as simply between a man and a woman, where the woman is the homemaker and the man is the breadwinner. It's also been used as the foundation for other developments with regard to rights for LGBT people, in particular with protections against discrimination, where numerous lower courts have recognized that it is inherently sex stereotyping to say men are supposed to be attracted only to women and women only to men, and people who are assigned the male sex at birth should present in ways that are prototypically male in a stereotypical sense, and have said that cannot be the basis of discrimination against those people. Now, interestingly enough, obviously, it was an extremely welcome development when the court issued the Bostock decision this past June, recognizing that Title VII's prohibition on sex discrimination covers sexual orientation and gender identity discrimination. The court's reading did not rely on sex stereotyping at all. And in fact, it was barely mentioned in the opinions. Instead, the court took a very textual analysis to say, you really can't consider someone's sexual orientation or gender identity without considering what their sex assigned at birth is. So let's assume that all Congress meant to prohibit was discrimination based on biological sex. That's still what's going on here, and therefore LGBT people are protected against, and of course non-LGBT people are protected as well, against discrimination based on sexual orientation and gender identity. The last thing I'd say is I do think that this concept of stereotypes has reach in numerous other areas of law. For example, racial profiling by the police is a form of stereotyping with tragic and often criminal results. Stereotyping in the disability context is what led Justice Ginsburg to write the Olmsted opinion, which recognized that it was impermissible to institutionalize people with disabilities who could fend for themselves and have full and satisfying lives in the community. And so I think she herself applied her anti-stereotyping theory beyond the context of men and women. The court has taken more steps in that direction, and I really hope that that is a trajectory that will continue despite what the composition of the court is likely to look at, as a segue to what I think is the next component.
Yes, well, there's so many more questions I'd like to ask. I want to ask Judge Wardlaw a question quickly, and then I do want to move a little bit to what may happen next. But I'm curious, Judge Wardlaw, you were appointed to the Ninth Circuit a few years after Justice Ginsburg joined the Supreme Court, and so you've had this overlap, and I'm wondering if when you've written opinions, was she ever there, sort of in your head, or present as somebody you were thinking about when you were writing, or were there ever cases where you wrote an opinion and then she played an important role in the court's resolution of the issue?
Yes and yes. I'll just really quickly say I have tried to model, particularly my dissent style and her style of writing. I try not to write a dissent at all. That's just a mere rebuttal of the majority opinion. I write the majority opinion. That's based on what she said. I also tell my clerks, every word, every sentence, every paragraph has to have a place and a meaning or it's gone. And I've learned these things from reading all of her opinions. But the one case I will talk about, and I'm going to talk about it more. The substance of the case was very important, but it was also an interesting growth development in Justice Ginsburg. The case was Reading versus Stafford Middle School District, and it was a case brought by Savannah Reading and her mother, alleging a Fourth Amendment violation because the middle school administrators had strip searched her, looking for 2 ibuprofen pills. And the history of our court, it got to the point where I was on an en banc panel, 10 male judges, me, the sole female. I so related to her in this one. And it came out 6-5. And I wrote the opinion that, yes, it was a Fourth Amendment violation. Well, it got to the Supreme Court, and it was again in this period, 2006 to 2009. They held oral argument, and after oral argument, I was dismayed. Many people were distraught. Many of the justices said, that's not a constitutional violation. When I was in gym, when I was in middle school, we took off our clothes every day, and sometimes they stuck stuff in my underwear. And somebody else said, I just think that, so what if she was embarrassed? She had talked a lot about her humiliation. So what if the drugs were at the campus, some other kid would end up dead? They were basically tone deaf. And it was at this moment, and it was clearly after conference. So this kind of tone deaf, uncomprehending of the actual situation that was going on, that Justice Ginsburg found a new voice, a voice that turned to the public. She went out and gave interviews to USA Today and other outlets and talked about this. And she just said, you know, they just don't understand. They've never been a 13-year-old girl. They don't know what it feels like. They don't know how humiliating that would be. And so they just can't comprehend this. It's very much along the theme of when she was in the 70s, trying to get the all-male Supreme Court to comprehend what gender discrimination was. Well, after that, an 8-1 decision came down by the Supreme Court ruling that the middle school administrators had in fact violated Savannah Redding's Fourth Amendment rights. And it was 8-1 on that point, but then the majority also found that there was qualified immunity, which is a subject for another day at great length. But, and so they did not hold the school administrators ultimately liable. But she clearly found a new level of the power of her voice to go to the public and have the public, which we all know that the public in some ways influences how the Supreme Court rules. But this was such a direct change in public opinion and understanding by the Supreme Court that I just think it's a fascinating case, both in the development of the law and in Justice Ginsburg's personal growth and in her influence on women and men beyond the judiciary.
Thank you. So we have several good questions in the Q&A, and I feel badly that we're not going to get to them. I'm going to share what a couple of them are in case any of you are able to work this in. But one is about her approach to hiring and whether her hiring fully fit with her values, especially her hiring of clerks, that, you know, that there wasn't as much racial diversity there as one might have expected, for example, from a judge with her values. I will also say Judge Watford, I'm thrilled that you clerked for her. I think we have one other UCLA grad that did, but when you look at our list, there's, a lot of Yale, and, a few other things there too, but not as much diversity in other ways. And somebody wondering about that. There's also a question about, without her voice, how is the court going to be changing its decision making, and taking that even beyond discrimination? And so, I mean, I guess I want to take these in turn to you, Professor Michaels, but I'd also like to look forward before we end. We don't have a lot of time left, but I'd like to ask you to reflect on what we might see going forward institutionally. I mean, it looks like we can expect President Trump to nominate somebody for this seat within days. Can you share any brief comments about the precedent of filling a seat this close to or immediately after an election, and more generally institutional concerns or dangers about the court's legitimacy and role, given the set of swirling conversations in which we find ourselves?
Thank you, Dean Mnookin. I do want to just underscore the question. I didn't see the question posed, but about the importance of inclusive hiring, and to think more carefully about who gets these privileged positions. And I think that's something that we should think about all the time when we think about all the justices as well. And I know that the folks who've clerked for Justice Ginsburg, the folks who've clerked for Justice Souter, there's a lot of extra opportunities that are available. And as someone who is on helping with the hiring process, there are more than, and I know my co-panelists will probably agree with it. There's an abundance of talent that are brimming from the law school, eager to apply. So I just hope that we can just remember how important it is to think about the importance of hiring and equity and inclusiveness and diversity when doing so.
Thank you. That's exactly why I wanted to at least mention that. I really appreciate you reflecting on that, even though I know that we're running out of time. But please go on. It's
a challenging issue, and it's a pipeline problem, and it's a reinforcing issue from from kindergarten on upward. And so judges and justices and law professors who are writing recommendations and college professors who are writing recommendations have to dig deeper and look more carefully, and not just assume others are doing that work for them, that you're getting a representative sample, but because the problem may be in college admissions, and it feeds on from there. In terms of the legitimacy of the court going forward, Dean, I think there's true and real and justified anger in this particular moment. But I think it's also important to recognize that the health of the court was precarious before this. And by the health, you could substitute the word legitimacy or the credibility or kind of the institutional role it's playing and how it's mediating disputes, maybe too many disputes, maybe not enough disputes, maybe in a certain way. There are, before we even get to the Merrick Garland to Neil Gorsuch switcheroo, we have to recognize that the majority of the appointments have been made by, of late, have been made by presidents who didn't win a popular vote and who have been affirmed by a Senate that does not command a majority of the country's support. So embedded into the problem of the court today is a number of other complex set of constraints that make it in some ways less surprising that the court may be increasingly out of step with where majoritarian sentiments are today. And so in some ways we have to think about the holistic problem as well when we think about strategies for going forward. The second point I would make is that to the extent that the courts are, as an institution, in a precarious situation, it's important to recognize that many of our governmental institutions are also in a precarious situation. If anything, the courts are in better shape than, I don't know, the Justice Department, depending on the day, the CDC, the Education Department, Homeland Security. So while we as a legal community hold the courts dear to our hearts, I think others may be thinking in terms of what are the priorities for reform, for renewal that this country, the healing that this country needs. There may be a need for more of an integrated approach than just cherry picking the courts, which I know folks are kind of gravitating to the idea of say, court packing. And I understand the justification for that, and I see its merits. But there's also this maybe a moment to think about de-emphasizing courts and the power they wield, particularly when it comes to adjudicating disputes between the political branches and whatnot. So I would just invite everyone to think more, to think holistically, as opposed to simply let's right the wrongs that happened in 2016 and now seem to be happening again, for at least by my lights, today, and think about it embedded in a series of challenges that only make the job of kind of moving forward greater. And that's how I would just invite the court packing ideas and other ways of leveraging the courts in different ways within an embedded structure of precarious sets of institutions and commitments that we're currently dealing with.
Thank you for that. I think there's a lot more to say about that and other topics, but we are just a couple of minutes beyond our time, actually. I do want to give our three other panelists the opportunity for any last word or concluding thoughts about Justice Ginsburg, her legacy, or the institutional future of the court. I think our sitting judges are probably not going to speak to that one. So Executive Director Samuels, how about the last word from you?
Well, thank you so much. And again, it's been such a privilege to participate on this distinguished panel, and thank all of you in the audience for joining us. I think that there was a question in the Q&A about how did Justice Ginsburg deal with rage and the feelings that being subject to denials and discrimination early in her career must have generated. And I think, it's interesting that Judge Watford talked about her calm demeanor, her serenity, her soft-spokenness. I think what she must have thought was, I'm going to get even. And she really did, because She changed the course of history, the course of the law, and I think the understanding for every woman in the country about what is possible for each of us as individuals. And for that, I am totally grateful. And I know that we all share that awe and inspiration and are committed to continuing her transformative work.
I just want to thank you for inviting me to participate in this talk memorializing Justice Ginsburg. Thank you very much. I feel very honored and privileged to have been able to participate.
Let me just echo that same thought. I was thrilled when I received your email saying that you were putting together this panel. Justice Ginsburg has been on all of our minds this past few days, and it was just great to be able to participate with my fellow panelists and sharing some thoughts about her.
Well, my great gratitude to all of you for participating and for giving us this chance to talk about her together, and to remember her as a lawyer, as a Supreme Court justice, and as a person. Thanks too to the audience for joining us this evening. We really appreciate you being here. I think we could have gone on for at least another. I won't even put a quantity of time to it, because I think there's a great deal more to say. But I'm delighted to have had this chance to talk about her and to hear your thoughts. So thanks for being with us, and have a good rest of your evening. Take care.
Thank you. Bye.
Bye.